The Honorable Chief Justice and Associate Justices of the Supreme Court.
The House will come to order.
The Senate will come to order.
Thank you, Mr. Chair and members. I've had a bill around for a few years now, and I'm hoping that this committee will pass it and send it on. It's an important reform for our courts. In 1994, I moved to Minnesota after having practiced law for many years in Virginia and Washington, D.C. And one of my first cases was a trial. I was representing a plaintiff in a contract dispute. It was tried in Hennepin County to a jury. The dispute was in the amount of $19,000. I represented those clients for many, many months. All that was at stake was $19,000. We couldn't go to conciliation court. The only choice we had was to go to Hennepin County District Court. I filed motions for summary judgment to try and get early results. The motion for summary judgment was decided on the first day of trial by the judge who hadn't had time to look at the motion for summary judgment. So we tried that dispute, a contract dispute, to a jury. And as I said, the plaintiff actually won, my client won. And with all the awards and fees and things, I think that the award was about $21,000. Members, it's extremely expensive for our courts to be trying to juries cases that are in dispute for less than $20,000. It's a huge expense to the litigants who are looking for justice and have to spend that much money in attorney's fees or have to defend actions with that much at stake with their attorney's fees. And so I looked immediately to see what that general jurisdictional amount is for our courts and for our conciliation court. It's still $7,500 as it was in 1994. It hasn't been changed since then. And so when I became a member of the Minnesota State Senate, I thought we should change that jurisdictional amount to $15,000. I think I would go to $25,000, but there are folks that think that it should be less than that. And what this provision would allow is an early determination in a conciliation court. It's a very good thing for the perspective of potentially settling lawsuits, because when a conciliation court referee looks at the case, the referee will say, well, you know, where's your evidence? And we'll examine the evidence, or maybe point out that there isn't sufficient evidence to establish a claim. And so it's really in the litigant's best interest to be able to take a case to conciliation court and not have to file in a court of general jurisdiction with attorneys and the high costs of litigation. So I think this is a very important reform. And just to have a little fun, I went and checked out what was going on in 1994, the last time we raised this level. And I just want to remind you that President Bill Clinton was in office. Sam Ortman, my 13-year-old son, had never been born. Tanya Harding and Nancy Kerrigan were going at it in Lilyhammer. Apple sold its first license for a Mac computer in 1994. The Citadel in Charleston, South Carolina, admitted their first female. The World Wide Web Consortium was formed that year. The Lion King was a big movie. Arnie Carlson versus John Marty on the ballot. Let's see, the cost of a gallon of gas. Anybody got an idea? $1.09. It's been a long time. A movie ticket was $4.08 on average. A new car, average price $12,350. And the media was following O.J. Simpson down the highway. So, members, I'm hoping that you'll support Senate File 506. And we have some folks here that are willing to testify in support, and there may be folks that would like to testify against. But I welcome Mr. Clavin.
Senator Ortman, before your testifiers begin, I will tell you, members, that I fully support Senator Ortman's bill. What you will find is that without raising this jurisdictional limit, you literally leave folks without a venue in which to have their disputes heard, because quite literally, for a $7,500 jurisdictional amount, you cannot hire an attorney to go into litigation, and with such a low limitation in conciliation court, they have no right of redress at all. So I would just indicate that I strongly support Senator Ortman's bill. Your next testifier, Senator Ortman, is your name, sir?
Bruce Clavin, for the record.
Please proceed.
Thank you, Mr. Chairman. Members, for the record, Bruce Clavin, represent the cooperative network formerly known as the Minnesota Association of Cooperatives. We have very brief testimony in support of the bill, Mr. Chairman. We have a little nifty handout you should have by now that I actually put together, and I know that this is accurate. I went back to the session laws myself, going back to 71, showing the development of the law. Senator Ortman has mentioned last time it was changed, it was in 94. Conciliation court allows the parties to represent themselves, and there's no discovery process, and it is far cheaper for both the plaintiff and the defendant in the court action. She gave you the history of the law. Let me tell you about the bill quickly. In 2009, she authored the bill for us back then. It was added as an amendment in this room one night onto an omnibus bill. Senator Moore carried that all the way to conference. It's passed the Senate floor before in this form, and it was made it to conference committee. It was dropped by the House at that time, and that was 2 years ago. We didn't do anything on it last year, and so the Senate has passed it once before. With me today is our Managing Director, Amy Frederick, who also would like to speak to the bill.
Thank you. Welcome to the committee. Please proceed.
Thank you, Mr. Chair. My name is Amy Frederick, as Bruce mentioned, and I'm the Vice President of the Cooperative Network, which a little bit more about our association, if you maybe knew us in the past as MAC. We represent any business that's structured as a cooperative in the state, from farm supply, grain, and fuel cooperatives and dairy cooperatives like Land O'Lakes, down to all the little Cenex gas stations, the farm credit institutions, housing co-ops, credit unions, healthcare co-ops, food co-ops, you name it. Minnesota is the #1 co-op state in the nation, and there's over 1,000 co-op businesses in Minnesota. And we bring a lot of economic development and jobs, pay a lot of taxes in the state, and give a lot back to our local communities. Member owners of a co-op share equally in the control of the cooperative, and the way we operate is one member, one vote, no matter how much you own of the cooperative. And so we're democratically governed, and it's a great way for businesses to be structured. I appreciate the opportunity to speak in support of SF 506. As the Senator mentioned, raising the limits reflects the inflationary costs of all the goods and services that, as you heard back in 1994, things cost a lot different at that time. And because our members are cooperatively owned, those increased costs for having to go to district court comes out of the pockets of their member owners, which are in large part in rural areas of the state, but also in urban areas as well. As mentioned, under current law, if the amount owed to a co-op is greater than the cap, the co-op is forced to go to district court, which really loses a lot of the efficiencies of conciliation court. Conciliation court is a lot more simplified, and for defendants results in savings due to the timely, expeditious nature. A lot of our cooperatives employ staff that do get involved with the collections process, and the staff end up spending hours and hours working on this. And so if we can simplify the process for them, those savings just go back to the member owners in our committees. And as just to kind of emphasize Senator Ortman's point, conciliation court is a very efficient process, which leaves district court available to do its job for some of the bigger jobs, and to save the smaller cases for conciliation court. So in closing, I'd like to thank Senator Ortman for her support, and for your time, Mr. Chair, and would ask the rest of the committee for your consideration. Thanks.
Thank you very much. Are there any questions for either of the testifiers from the committee? Senator Marty.
Mr. Chairman, Senator Ortman, I support your bill. I kind of thought 20,000 would be a good compromise between 15 and 25. And it was interesting to see the chart that co-ops hand out. For a 5-year period in there, we really were catching up for a while, and then we fell behind. And I don't know what the magic number is. I just know that I think a lot of people just don't go to court because of it. But the fiscal note doesn't talk about any savings in district court. Is the assumption that everybody who would go to conciliation court isn't going to court at all now? Or did I read this wrong?
Senator Ortman.
Well, Mr. Chair and Senator Marty, anyone in the conciliation court has the immediate right to a trial de novo, and which means start from scratch and have an entire trial. And so I think that's been the basis of what I think are very cautious fiscal notes here. I think there would be more people that would access justice in conciliation court, and that there would be court savings, but that's never been a part of the fiscal notes as I've seen them.
And
Senator
Mr.
Martin.
Chair, maybe Mr. Turner knows, because he was around here by 93, 94, I think, maybe not. But, yeah, you were here then. Did we have a decrease in court costs when this passed last time?
Mr. Turner.
You know?
Mr. Chairman, Senator Marty, I don't remember that far back.
He's just a kid.
But the fiscal note is based on, they're not saying people that are going to go to, or would be going to district court are going to be going to conciliation court. That'll be the same amount of cases in district court. The fiscal note is based on there being more conciliation court cases.
Because, Mr. Chair,
Senator Marty.
I just happen to think there will be a decrease, a significant one, not anywhere near the number of increase in conciliation court. Senator Ortman, what would you think about an amendment to increase it to 20 and 10?
Senator Ortman.
Senator Marty, I would be favorable to that amendment. I've been proceeding cautiously because I think some people don't understand what this amendment or this bill is trying to accomplish, and it really is about access to justice and early resolution of disputes. And so I would appreciate that if the members can support that.
Mr. Chairman, then I'd like to move on line 110 to strike 15,000, insert 20,000, and strike 7,500 and insert 10.
Senator Marty moves on line 1.10, strike $15,000, add $20,000, strike $7,500, and put in $10,000. Do any of the members of the committee have any questions regarding the amendment or comments? Senator Ortman, do you wish to address the amendment, or do you simply want to move or move forward with it?
Mr. Chair, I support Senator Marty's amendment.
Any further questions regarding the amendment, the oral amendment? Hearing none, all those in favor signify by saying aye.
Aye.
All those opposed, same sign. The amendment is adopted.